Welcome, everyone. Good evening. This is Judge Paul Burdick, and I understand we are having teams competing at our semifinals. Congratulations to these two teams to reaching this stage of 2021-2022 California mock trial competition. I'd like our student bailiff to please call our proceedings to order at this point. I believe we have Deputy Higgins in that role.
All rise. Superior Court of the State of California, County of Santa Cruz is now in session. Judge Burdick presiding. Please be seated and come to order. Please turn off all cell phones and refrain from talking.
Thank you, Deputy. Welcome, Team C and E. Again, congratulations for reaching this stage of the competition. And you folks have been through this path before, so I'm going to turn immediately to the team introductions. So to help myself and the attorney scores, I'd like to begin with the prosecution. If you folks will tell us your names and state your roles, please.
Good evening, Your Honor. Scoring attorneys. My name is Sierra Fong, spelled F-O-N-G, and tonight I'll be presenting the pretrial motion for the prosecution. May our attorney team please introduce themselves?
Yes, please.
Good afternoon, Your Honor. Scoring attorneys. My name is Andres August, spelled A-U-G-U-S-T. Tonight, I'll be presenting the opening statement for the prosecution, as well as the direct examination of Angel Russell and the cross-examination of Danny Emlin.
Good evening, Your Honor. Scoring attorneys. My name is Madison Alwell, spelled A-H-W-A-L. Tonight, I will be conducting the direct examinations of Dr. Charlie Dunn and Terry Edwards, as well as the cross-examination of Francis Yazzie.
Good evening, Your Honor. Scoring attorneys. My name is Gregor MacDonald, spelled M-A-C-D-O-N-A-L-D. Tonight, I will be delivering the direct examination of Deputy Sheriff Tony Garrett, the cross-examinations of Dr. Tyler Clay and the defendant, Jamie Kobe, and the closing arguments for the people. May our witnesses please introduce themselves?
Yes.
Good evening, Your Honor. Scoring attorneys. My name is Dylan Childs, spelled C-H-I-L-D-S, and tonight I'll be Angel Russell.
Good evening, Your Honor. Scoring attorneys. My name is Mason Davis, D-A-V-I-S, and tonight I am Terry Edwards.
Good evening, Your Honor. Scoring attorneys. My name is Ari McNeil, spelled M-C-N-E-I-L, and tonight I am Deputy Sheriff Tony Garrett.
Good evening, Your Honor. Scoring attorneys. My name is Dave Ruiz Martinez, spelled R-U-I-Z-M-A-R-T-I-N-E-Z, and tonight I am Angel Russell.
Good evening, Your Honor. Scoring attorneys. My name is Evie McNulty, spelled M-C-N-U-L-T-Y. May our clerk please introduce themselves?
Please.
Good evening, Your Honor. Scoring attorneys. My name is Anais Hewitt, spelled H-U-E-T, and I will be the clerk for tonight's trial. I will give visual and verbal time signals of 2 minutes, 1 minute, 30 seconds, and stop. May our attorney coaches and faculty advisor introduce themselves?
Yes.
Good evening, Your Honor, and scoring attorneys. My name is Sarah McCarthy. I am attorney coach for Team E.
Good evening, Your Honor. Scoring attorneys, Diana August, attorney coach for Team E. And I did just want to note that one of our understudies mistakenly introduced himself during the introductions. The student who is portraying Angel Russell is going to be David Ruiz Martinez.
Thank you.
Good evening, Your Honor. My name is Devin Lincoln. I am faculty advisor for Team E.
Thank you very much. I believe that completes the prosecution team participants. And with the defense team, please state your names and your roles, please.
Good evening, Your Honor. Scoring attorneys. My name is Serena Manildi. That's M-A-N-I-L-D-I. Pronouns she, her. And tonight I will be presenting the pretrial motion on behalf of the defense team. May the attorneys introduce themselves?
Please.
Good evening, Your Honor. Scoring attorneys. My name is Molly Endert Tatum. That's E-N-D-E-R-T-T-A-T-U-M. Pronouns she, her. Tonight, I'll be conducting the direct examination of Jamie Kobe, the cross-examination of Tony Garrett, and presenting the closing arguments on behalf of the defense.
Good evening, Your Honor. Scoring attorneys, my name is Zora Martin Etemadi. That's MARTIN space ETEMADI. My pronouns are she, her. Tonight, I'll be conducting the direct examination of Dr. Tyler Clay, the cross-examination of Dr. Charlie Dunn, the cross-examination of Terry Edwards, as well as presenting the opening statements on behalf of the defense.
Good evening, Your Honor. Scoring attorneys, my name is Stephanie Garcia Mora. That's GARCIA-MORA, pronouns she, her. And tonight I will be conducting the direct examination of Francis Yazzie and Danny Emling, followed by the cross-examination of Angel Russell. May our witnesses please introduce themselves?
Yes.
Good evening, Your Honor. Scoring attorneys, my name is Shalin Joshi. That's JOSHI, pronouns he, him. And tonight I will be Francis Yazzie.
Good evening, Your Honor. Scoring attorneys, my name is Connell Barber. That's BARBER. My pronouns are he, him, and tonight I am Dr. Tyler Clay.
Good evening, Your Honor. Attorney. My name is Eva McCarthy. That's MCCARTHY, pronouns she, her, and tonight I am Danny Emling.
And Ms. McCarthy, your device might be a little bit low in volume. I'm not sure. You might want to look into that as we go forward.
Good evening, Your Honor. Scoring attorneys, my name is Maisie Higgins. That's HIGGINS, pronouns any. And tonight I am Jamie Kobe. May our bailiff please introduce themselves?
Yes, please.
Good evening, Your Honor. Scoring attorneys, my name is Abigail Higgins. That's HIGGINS. And tonight I will be the bailiff. May our teacher coach introduce herself?
Please.
Good evening, Your Honor. Scoring attorneys, my name is Margaret Starrett, and I'm the teacher advisor for Team C. May our attorney coach please introduce themselves?
Yes.
Good evening, Your Honor. Scoring attorneys, my name is Layla Sayar, and I'm the attorney coach for Team C.
I believe that completes our team announcements and participants. So before we commence with pretrial arguments, I'm going to go over with all of you the instructions and rules. You must complete your presentations within the specified time limits. The clerk will signal you as your time for each section of the presentation begins to run out. When your total time for each section runs out, you will be stopped, even if you have not finished. Attorneys must call 4 witnesses within the time allotted. This is a bench trial. At the end of the trial, I will render a verdict of guilty or not guilty in relation to the charge brought. The teams will be rated based on the quality of their presentation, independent of my verdict. Barring unforeseen circumstances, no recesses will be called. If for any reason a recess is necessary, team members should remain in their appropriate places and should have no contact with spectators or coaches. Remember that objections are limited to the California Mock Trial Simplified Rules of Evidence located in the case packet. If there are no questions, the pretrial arguments will now begin. So calling the hearing to order as it relates to pretrial motions, both sides have 4 minutes to present their arguments. The defense will begin. I may interrupt to ask clarifying questions. Time spent answering my questions is not included in the 4-minute time limit. At the conclusion of your arguments, each side will be offered 2 minutes of rebuttal time. Remember that the rebuttal time is to be used to counter your opponent's arguments. It cannot be used to raise new issues. Is counsel for the defense ready to begin?
Yes, Your Honor.
And again, for the benefit of our scoring attorneys, if you'll tell us your name.
For the convenience of the court, my name is Serena Manildi.
Thank you. Would you please summarize your arguments, counsel? You may begin.
Thank you, Your Honor. The defense moves to strike the surveillance footage of Kobe's backyard, obtained without a warrant, depicting snake feeding tongs because the Fourth Amendment prohibits unreasonable searches and seizures. The constant surveillance of Jamie's yard was a search, and it was an unreasonable search. In Katz versus United States, FBI agents attached an electronic listening device to a public phone booth. The court ruled this as an unlawful search. In doing so, the court established a two-part test. One, has this person shown actual expectation of privacy? And two, does society view it as reasonable? Kobe showed an expectation of privacy because they had a 6-foot-high wooden fence surrounding their entire yard. When Kobe realized there was a camera pointed at their backyard, they asked for the camera to be taken down, just as any person with a reasonable expectation of privacy would do. But Smith kept the camera up anyway. Society views this expectation as reasonable because society is you and me, ordinary people. An ordinary person would not expect the government to be watching what you are doing in your own backyard. An ordinary person deserves to do and have what you want in your own yard without the government seeing it.
Counsel, let me interrupt you briefly to ask, given the existence of this 4-foot by 3-foot chain link gate fence, which is immediately adjacent to a public park, unlocked, obviously the backyard is open to plain view of anyone walking by the park or using the park. Isn't that true?
Excellent question, Your Honor. While there was a small chain link gate, the rest of the yard was surrounded by a 6-foot-high wooden fence that could not be seen through. One would have to go out of their way to walk up to the gate and peer through the yard and see the tongs. Even so, Smith had the camera up for over 6 months. That's over 6 months of intensive surveillance, which is very different from someone passing by and looking into Kobe's yard.
So you're still of the view that there's a reasonable expectation of privacy, despite the fact that this area of the backyard is open to public viewing, and despite the fact that this sign above the camera says, "Smile, you're on camera," and despite the fact that Smith was asked to remove the camera, he didn't. You really have the view that this is a reasonable expectation of privacy, despite all those facts.
Yes, Your Honor. You pointed out that there was a "Smile, you're on camera" sign. And you're right, Kobe was aware that the camera was up, but Kobe was not aware that the government was using the camera as well as their neighbor.
Very well. You can continue, counsel.
Thank you, Your Honor. Schaefer versus City of Boulder shows that Kobe's yard constitutes the curtilage of their house. In Schaefer's case, the police gave Schaefer's neighbors cameras to spy on their backyard. The court ruled that this did violate the Fourth Amendment. One of the reasons the court held this was because the yard was surrounded by a 4 to 5 foot high fence. In our case, Kobe's yard fence was 6 feet high. In Schaefer's case, the court looked at 1, the duration of surveillance, and 2, the government's ability to collect information they would otherwise have been able to observe. In Schaefer's case, the camera was up for 65 days. In our case, Smith had a camera pointed into Jamie's backyard from October 10th to April 29th. That is over 6 months of intensive surveillance. As for the government's ability to collect information they would otherwise have been able to observe, Kobe had a large fence surrounding their entire property. The police would have been unable to collect the footage of the tongs without the 10-foot-high camera or physical intrusion. In United States versus Jones, officers attached a tracker to the defendant's private vehicle. The court held that the tracker violated the defendant's rights to the Fourth Amendment. Just like the tracker in the Jones case, Smith's camera was on 24 hours each day. The court emphasized that we are in an era where physical intrusion is unnecessary for there to be an unconstitutional search due to the many forms of surveillance. In United States versus Jones case, the government was watching where the defendant's private vehicle was going. In our case, Kobe's landlord and the government were constantly surveying Kobe's backyard without their permission. Kobe was aware that the camera was up, but they were not aware that the government was watching them as well as their landlord. If you deny this motion, you are saying that it is okay for the government to put cameras up and spy on your neighbors without their permission. We, the defense team, ask that you grant the motion and exclude the evidence that was obtained unlawfully. Thank you.
Thank you, counsel. Counsel for the prosecution, ready to begin?
Yes, Your Honor. For the convenience of the court, my name is Sierra Fong. Your Honor, and may it please the court. Last October, Eric Smith positioned a 24-hour video surveillance camera on his own property to protect it from theft, vandalism, and potential bodily harm. Defendant Kobe received notice of this camera and was aware of its functionality to protect Smith's property. The image obtained from the camera is admissible for 3 reasons. First, Kobe's backyard does not constitute as curtilage of their residence. Second, because it is in plain view and adjacent to a public state park, Kobe's property has no societally reasonable expectation of privacy. Finally, the defendant received notice of the surveillance that was not of his home but of Smith's property, therefore failing to establish an expectation of privacy. There is no reasonable expectation of privacy because the observations were made in a public space and on Smith's property. In California versus Cirillo, the court established that non-intrusive observations, which take place either from somewhere where one is allowed to observe, are consistent with the Fourth Amendment. The victim placed a non-intrusive camera in their own backyard, which was not installed with the intention of monitoring the defendant's private life, but rather to protect Smith's property from theft and vandalism. Additionally, Kobe's backyard does not constitute as curtilage of their residence under the 4-prong test established in U.S. versus Dunn, which
Let me stop you right there. And I know you're not seeing me on video. Hopefully you're hearing me. I'm working on my getting my video feedback up. But you say that Kobe's backyard is not within the curtilage of the home. Doesn't Schaefer versus City of Bakersfield establish that using those standards that it is? How do you distinguish?
Yes, Your Honor, you raise a good point. However, in Schaefer versus City of Boulder, the defendant clearly established an expectation of privacy. As I'll address later, in Schaefer versus City of Boulder, the defendant asks both police and his neighbors multiple times to take the cameras down and adds additional feet of wood to his backyard fence, which entirely differs from our case.
All right, thank you.
Okay. In our case, Kobe's backyard is directly adjacent to a public state park and is adjacent to Smith's own property. Moreover, the 4-foot-tall chain link fence causes the entirety of the yard to be visible to the public without one ever having to take a single step onto the property. Kobe took no steps to protect the area from observation, nor did he request that his landlord take any actions of a similar nature.
2 minutes.
The camera also did not serve any purpose that could not have been performed manually. In United States versus Knotts, law enforcement officers used a radio transmitter to track illicit chemicals into a cabin. The court ruled that the actions of law enforcement officers were not in violation with the Fourth Amendment. As the technology did not serve any function that police could not have performed visually, it only made the process easier. Sheriff Garrett would have come several more times, but instead, due to the nature of the calls, it seemed feasible to place a camera and have it serve in the same capacity.
So let me ask you about the technology. I know in Kylo versus US, they were talking about thermo image technology. Here we have Deputy Garrett providing the security camera with this long-term cloud storage capabilities. Why is this any different than what was condemned in Kylo versus US being searched without a warrant?
It is stated that this camera is publicly available, and so this is not superior technology, unlike in Kylo.
Very well. Proceed, counsel.
Unlike in Schaefer, as to reiterate, Kobe never establishes his expectation of privacy. For 201 days, Kobe was well aware of the camera's presence, but only notified Smith once. Despite the sign attached to the camera, Kobe either forgot about it or was unconcerned about its presence. In Schaefer versus City of
1
Boulder,
minute.
the defendant clearly established an expectation of privacy by asking the police and his neighbors multiple times to take the cameras down, and even added additional feet of wood to his backyard fence. There is no Fourth Amendment violation of the defendant because the defendant did not establish a reasonable expectation of privacy by any means, verbal, physical, or societal. Furthermore, the surveillance was that of Smith's own property,
30 seconds.
plain view, and that is not enclosed in any curtilage. For these reasons, the people request that the court deny the motion and admit the image into evidence. Thank you, Your Honor.
Thank you, counsel. Defense rebuttal? I'm hoping I haven't lost my technology. Are you able to hear me?
Yes,
All
I
right,
am able to hear you.
defense rebuttal. I'm still working on getting my video feedback. I apologize for that.
Thank you, Your Honor. May I begin?
You may.
Thank you. The prosecution argued that the camera was up to protect Smith from theft and vandalism. But how does a camera pointed at someone else's backyard protect Smith's own backyard? That does not make sense. The prosecution also argued that Schaefer is different because Schaefer complained to the police about the camera, but Kobe did also complain to the police. And while they did only complain once, one should not have to object at all for it to be an unlawful search. The fact that Kobe did complain just further proves that it was unlawful. The prosecution also argued that the camera did not collect information that wouldn't have been able to be collected by someone just walking by. But this is incorrect because the camera was up for over 6 months, while someone walking by would have only been able to look into the yard for a couple seconds. Thank you.
Thank you, counsel. Prosecution rebuttal?
Yes, Your Honor. May I proceed?
You may.
The defense places a great emphasis on the duration of the surveillance. However, within this time of 201 days, the defendant had 201 days to object to the camera's presence, yet he only notified Smith of the camera's presence once. And in response to previous disagreements between Kobe and Smith, Kobe clearly showed no hesitation in regards to expressing his discontent with Smith's actions. Therefore, a single mention of the camera by no means shows a reasonable expectation of privacy. Additionally, the defense also maintains that the camera recorded information that would be unable to be observed or by the public. However, previous to the installation of the camera, Sheriff Garrett's actions served the exact same purpose. Previously, the sheriff responded to over a dozen calls due to Smith and Kobe's
1 minute.
Smith could not constantly monitor his yard, nor could he further require the sheriff's constant presence every time he feared Mr. Kobe's intrusion. Thus, the most feasible way to protect his property was to place this 24-hour video surveillance camera to upload footage of anyone crossing over to his property. Thank you.
Thank you, counsel. Before I rule on the motion, students may confer with their attorney-teacher coach regarding any trial irregularities. I'll allow 30 seconds for that to be done. Please do so now. I'm having technical difficulties. Hopefully they are resolving and you folks can all hear me. Any trial irregularities from the prosecution team?
Your Honor, the prosecution has no irregularities at this time.
Any defense noted irregularities?
No defense irregularities.
Very rule. The matters being submitted. Going to deny the motion to suppress evidence. I'm satisfied based upon what I've heard that the defendant did not have a expectation of privacy given all of the circumstances here. The defense motion to suppress is denied. So we will turn to the trial. And the attorneys should be presenting their physical evidence for inspection. Prosecution, do you have any physical evidence you would like to present for inspection?
Your Honor, at this time, we would like to mark all exhibits for identification throughout the trial, A through E.
You may do that. Defense, do you have any physical evidence you would like to present for inspection?
Yes, Your Honor, we'd like to mark A, B, and E for evidence, please.
Very well. Those items are marked and will be recognized. The people of the state of California charged the defendant Jamie Kobe with first-degree murder or voluntary manslaughter of Eric Smith. We will begin with opening statements. Prosecution will deliver its opening statement. No questioning will be permitted during opening statements. Prosecution, are you ready to present your opening statement?
Yes, Your Honor.
You may do so.
Thank you. Jamie wanted him dead. Jamie had the weapon. Jamie killed Eric Smith. Motive, means, and opportunity. The defendant had endured months of harassment, humiliation, and bullying from Eric. The defendant was Eric Smith's tenant, and you will hear evidence that Eric Smith cut the power to the defendant's home. This upset them. You will hear evidence that some people did not like Eric Smith as a landlord. But those opinions do not justify his murder. The defendant's feelings about Eric Smith cutting off power and their opinion that their mother was killed because the power was cut off is the most damning evidence of motive in this case. We hear from Terry Edwards, who heard the defendant say, "That was it. I am going to kill him." And Jamie was finally going to do it. You'll hear evidence of the defendant's means and opportunity when Angel Russell saw them standing in front of the mailbox with a snake cage. Jamie put that snake inside the mailbox with the intent to kill the victim. So when the victim opened the mailbox, he would be attacked by the weaponized snake. How are we to be assured that it was Jamie Kobe who did this? We'll hear from Deputy Sheriff Tony Garrett that Jamie's house was full of evidence that they had a special knowledge of venomous snakes. And after Eric Smith was murdered, Jamie got rid of all such evidence, which is a fact that supports his guilt. Dr. Charlie Dunn will testify that Eric Smith died of that snake bite regardless of any underlying health conditions. Do not be distracted. Listen to the facts. The defense will try to argue that Eric Smith was responsible for his own death. Do not be fooled. Jamie Kobe was perhaps more venomous than that snake. Jamie Kobe wanted Eric Smith dead, and they weaponized the snake to do it. At the end of this trial, after you have heard all the evidence, we will ask you to find Jamie Kobe guilty of first-degree murder. Thank you.
Thank you, counsel. At the conclusion of that opening statement, the defense may present their opening statement or wait until the prosecution has completed their case in chief. Defense, would you like to present your opening statement at this time?
Yes, Your Honor.
You may do so.
Thank you. Good evening, Your Honor. My name is Zora Martin Etemadi, and I'll be representing Jamie Kobe on behalf of the defense. My client, Jamie Kobe, is being wrongly accused of the first-degree murder and voluntary manslaughter of her neighbor and landlord, Eric Smith. Today, the defense aims to show you evidence that will disprove these accusations. Though yes, it should be noted that Ms. Kobe and Mr. Smith did not get along on both social and professional terms. Ms. Kobe is a hardworking person with a passion for gardening. Ms. Kobe is also a kind and devoted caregiver to her oxygen tank dependent mother, who she took care of up until her death in late April. Unfortunately, Ms. Kobe was short of money because of the pandemic and could not pay her rent in full, upsetting her landlord, Eric Smith. Mr. Smith would shut off her power repeatedly, and eventually, Ms. Kobe's mother died because of this, when her oxygen tank sadly ran out of power. Our first witness, Francis Yazzie, will testify to how Ms. Kobe and Mr. Smith would have disagreements, but also how Ms. Kobe is a truly kind-hearted person who would never harm him. Mr. Smith shows up to her mother's funeral uninvited and begins acting inappropriately, rightfully upsetting Ms. Kobe. She is attending her own mother's funeral, who died because of an action Mr. Smith took, and he shows up uninvited, creating obvious emotional turmoil. The events of the funeral will be testified to by another neighbor and the defense's third witness, Danny Emling. She will explain their altercation and how it reflects Mr. Smith's reputation of being an unkind and self-destructive person. On April 29th, 2021, as Mr. Smith was retrieving his mail, he was bitten by a rattlesnake that was in his mailbox and later dies as a result. The Mojave rattlesnake was found without its rattle. Your Honor, the prosecution will try to convince you that Ms. Kobe removed the rattle and then planted the snake in Mr. Smith's mailbox. However, there's plenty of natural evidence for the snake's presence there. This evidence will be analyzed by Dr. Tyler Clay, an acclaimed herpetologist with numerous degrees and even a published book on snakes. Finally, Your Honor, we'll hear from Jamie Kobe herself, an honest admission to her dislike of Mr. Smith. She will explain in detail how Mr. Smith continuously tried to provoke her and did in fact anger her, but would never harm him. Ms. Kobe was simply going about a normal day in her life and had no connection to his death. Your Honor, of course, Ms. Kobe was mad at Mr. Smith. Her mother just passed away and was feeling an influx of emotions, but emotions don't have direct correlation with committing acts of murder. Ms. Kobe had every right to be angry at Mr. Smith, but will prove herself to be a kind and hardworking person who could never dream of hurting an animal, let alone a neighbor. Your Honor, the prosecution wants you to believe that Ms. Kobe had planned out this heinous attack in advance. The defense will prove to you that there's more than enough reasonable doubt to dispute these claims. Your Honor, to convict my client, my opposing counsels have to prove beyond a reasonable doubt that the acts Ms. Kobe is being accused of were premeditated, deliberate, and committed willfully. At the end of this trial, you will see that they have fallen short of meeting this burden, and therefore the defense asks you to find Jamie Kobe not guilty on all charges. Thank you.
Thank you, counsel. We will now begin with the presentation of evidence. The prosecution calls its witnesses and conducts direct examination. Prosecution, you may call your first witness.
Yes, Your Honor. Before the prosecution calls their first witness, the prosecution requests a time check on on statements.
Prosecution has 6 minutes and 30 seconds for closing arguments, and defense has 6 minutes and 9 seconds for closing arguments.
Thank you. The prosecution calls Angel Russell.
Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Please state your...
My name is David Ruiz Martinez.
For the convenience of the court, my name is Andres August. Please state your name and occupation for the court.
My name is Angel Russell, and I'm a line worker in Burnsley County.
What were you doing on April 29th and 30th?
I was working on a line pole over on Raptor Road.
Could you describe your location on that day?
Yeah, I was right by 46601 and 46603, as well right by the mailbox.
I'd like to direct your attention to what has been pre-marked as Exhibit C for identification. Do you recognize this?
Yes, I do.
What do you recognize this as?
An aerial view photo of Raptor Road.
Is this a faithful and accurate representation of the photo at the time it was taken?
Yes, it is.
Your Honor, may Exhibit C be moved into evidence?
Yes.
What happened on the morning of April 29th?
I saw a suspicious figure come out of 46603. They were wearing jeans and a long sleeve tee.
And who was the person you noticed?
The person was Jamie Kobe.
Did Jamie have anything with them?
Yeah, they had a cage and a duffel bag of some sort.
I'd like to direct your attention to what has been pre-marked as Exhibit E for identification. Do you recognize this?
Yes, I do.
What do you recognize it as?
The cage I saw Jamie Kobe holding.
Is this a faithful and accurate representation of the cage you saw?
Yes, it is.
Your Honor, may Exhibit E be moved into evidence?
It may.
How was Jamie acting with the cage?
They were acting kind of sporadic. They kept looking down at the cage multiple times.
And later, while you were working on Raptor Road, did you see Eric Smith?
Yeah, I saw Smith come out of his house. I gave him a little wave and then I returned back to my work.
And what happened after that?
Well, I looked back to him and he reached into his mailbox and out came a snake that bit his wrist.
How did Eric react to this?
Well, he fell on the floor. He was groaning, but after that, he stood up and he screamed Jamie.
And the next day, did anything happen?
Sadly, I came back to work and I saw Smith face down on the ground and he was dead.
And did you work or how long did you work across from the victim's mailbox on April 29th?
I worked from the morning into evening.
And during those hours, did you see anybody other than the defendant near the victim's mailbox?
The only other person I saw was Jamie Kobe.
Thank you, Your Honor. No further questions.
Thank you. Cross-examination?
Yes, Your Honor. May I begin?
You may.
For the convenience of the court, my name is Stephanie Garcia Mora. Okay. Could you confirm that on April 29th, 2021, you were working on the power lines 100 feet down from Mr. Smith's house?
About 100 feet.
And you saw a person standing in front of the mailbox at 46601 on that day, yes?
Yes.
But you did not see who this person was, correct?
Not at the time, no.
But in your direct, you did state that this person was Jamie Kobe, but to be clear, at the time you did not know this person. You didn't see who this was?
Objection, Your Honor. This question calls for speculation.
Overruled.
Okay. And yet, sorry, Your Honor. And from the end of that day, you saw this person carrying a cage, correct?
Yes.
But you couldn't see that there was anything inside the cage, yes?
Well, I was working the whole day.
You later saw Mr. Smith coming out to his mailbox at around 12 p.m., correct?
Yes.
And you saw him being attacked by the snake, yes?
Well, bitten, yeah.
And you were panicked, of course?
Well, yeah.
And you knew that Mr. Smith's wrist was severely injured, correct?
Well, I couldn't know, but I thought he might have been.
And you didn't seek any help, correct?
I did try to yell for help.
And the next day you saw Mr. Smith face down, correct?
Yes.
And 40 minutes later, the sheriff came, yes?
Yes.
And you told the sheriff about your interaction with Mr. Smith from the previous day, correct?
I did.
And you told the sheriff that you had seen someone from 46603 at the mailbox of 46601, yes?
Yes.
But you did not see that person open nor close the mailbox once, yes?
Well, no, but they were standing right next to it.
And to be clear, as you had mentioned earlier, you were indeed working the entire day, yes?
Yes.
Thank you, Your Honor. No further questions.
Would the prosecution like to redirect?
Yes, Your Honor. Who was the person that you saw approach the mailbox in front of 46601?
It was Jamie Kobe.
Thank you, Your Honor. No further questions. May the witness be excused?
Witness may.
And the prosecution requests a time check on direct examinations.
Prosecution has 11 minutes and 8 seconds left for direct and redirect examination, and defense has 7 minutes and 38 seconds left for cross-examination.
Prosecution ready with their next witness?
Yes, Your Honor, the prosecution calls Terry Edwards to the stand.
Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
For the convenience of the court, my name is Madison Alwell.
For the convenience of the court, my name is Mason Davis.
Good evening, Mr. Edwards. Please introduce yourself for the court.
My name is Terry Edwards, and I'm a retired lawyer.
Are you familiar with Eric Smith?
Yes, he and I are friends.
And do you know the defendant?
Yes, I've lived on the same road as the defendant for a long time.
Can you please tell me about yours and Mr. Kobe's relationship?
It was a friendly relationship that has edges.
What was your relationship with Jamie like?
He did some work for me, but did not end up finishing the job, unfortunately. But past aside that, he invited me to their mother's funeral.
And where were you on April 28th?
I was attending Jamie's mother's funeral.
Did you see Jamie at the funeral?
He was there.
And how did Jamie seem?
Jamie looked angry. I overheard several remarks like, "This was it," and Jamie was
Objection,
finally
Your Honor,
going
this
to
is
do it.
hearsay. Your Honor.
Folks, we're having technical difficulties. Thank you for your patience. We'll be right with you. Everybody, thank you for your patience. We're working on the technical difficulties with the judge's video and his audio. We'll be back with you shortly. Thank you for your patience.
Your Honor, we can't hear your audio.
Am I now audio available? All right, I apologize there. I'm not sure what happened in my chambers, but I'm on the bench now, and prosecution, I believe, may call its next witness. Or actually, were we dealing with an objection? I'm sorry. I needed to know what the response.
Yes, Your Honor.
What the response to the hearsay objection was?
Yes, Your Honor, the statement that the witness repeated was stated by the defendant, which is admissible, which is a statement admissible by a party opponent.
Yes, I'm going to overrule the objection.
Mr. Edwards, did you get to finish your answer?
If we could have the question asked again, that would be great.
How did Jamie seem at the funeral?
Jamie looked angry and made several remarks like this was it, and Jamie was finally going to do it. Whenever I asked Jamie what those remarks were about, Jamie told me he did not want to talk to me and told me to go away.
And did you see Eric at the funeral?
Eric was also there.
Did Eric interact with Jamie?
I saw them go outside and I followed to prevent any physical conflict.
And then what happened after that?
Eric said something to provoke Jamie. Then Jamie said that they did not want Eric at the funeral and then blamed Eric for Jamie's mother's death. Eric then responded, blaming Jamie for Jamie's own mother's death.
How did this argument end?
I saw Jamie clench a fist, so I suggested that they separate and discuss at another time. Jamie said never, hurried off to their car, and Eric shortly decided to go home also.
What did you do after the funeral?
Few hours after the funeral, I drove to Jamie's residence to check up on them. It was an emotional day. And I saw Jamie in their garden.
And what was the defendant doing?
Jamie was in their garden looking emotionally drained. And when I rolled down the window to talk to them, I heard the words screamed, "I'm going to kill him," from
Objection, Your Honor, this is hearsay.
Counsel, the response?
Similarly to the other objection made, this statement was said by the defendant, so this statement is admissible by a party opponent.
Overruled.
Mr. Edwards, would you like to finish your answer?
Yes, thank you. So Jamie said, I'm going to kill him when I was about to roll down the window. I thought nothing of it and suggested that they get some rest. And Jamie said they will do it after they finish something important.
No further questions, Your Honor.
Cross-examination?
Yes, Your Honor, may I proceed?
You may.
For the convenience of the court, my name is Zora Martin Etamati. You live near Smith and Kobe, correct?
Yes, I've lived on Raptor Road.
And you would know that Kobe and Smith did not get along?
Yes, they got into several fights over rent.
And so being close to both of them, you know that Smith would continue to demand rent from Kobe despite the pandemic eviction moratorium.
Yes, even when I told Eric that it was the pandemic moratorium, he still was very frustrated.
And in fact, Smith said that he wanted to make Kobe pay in other ways.
Yes, but
Your Honor, this question calls for hearsay.
Your Honor, may
Overruled.
And even though Kobe wasn't happy with the situation, they did not move out because of their ill mother.
That is what I thought.
And Kobe's mother sadly passed away, and you found out about her funeral from Kobe himself.
Yes, I was invited at a grocery store.
And you went to the funeral.
Yeah, to pay my condolences.
And at the funeral, you witnessed a fight between Kobe and Smith.
Yes, it was uncalled for.
So you would say Smith was acting inappropriately during this altercation?
I would say that.
Objection, Your Honor. This question calls for an opinion.
Sustained.
Your Honor, may be heard?
Yes.
This is rationally based on the perception of Edwards as they were there to see the altercation take place.
I'm going to sustain the objection.
And so after this altercation, Edwards, you were concerned for Kobe's mental state?
It was an emotional day. So
And
yes, I was.
Yeah. So you went to check on them after the funeral?
Yes, I drove by the residence.
And you saw Kobe gardening in their front yard?
I saw Kobe in their garden.
But you came to the conclusion that Kobe was emotionally exhausted after the day's events?
Yes,
And that they wanted to escape via gardening?
that is what I thought.
Thank you. No further questions.
Going to redirect by the prosecution.
No redirect, Your Honor. May this witness be excused?
Witness may be excused. And the prosecution's next witness.
Yes, Your Honor. At this time, the prosecution would like to request a time check for direct examination.
Prosecution has 8 minutes and 29 seconds left for direct and redirect examination, and defense has 5 minutes and 57 seconds left for cross-examination.
Thank you. At this time, the prosecution calls Deputy Sheriff Tony Garrett to the stand.
Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
For the convenience of the court, my name is Gregor MacDonald. May I proceed, Your Honor?
You may.
Good evening, Deputy Garrett. Could you please introduce yourself to the court?
Good evening. My name is Tony Garrett, and I've been a deputy sheriff in Burnsley County for about 20 years.
And in that time, have you ever encountered a man named Eric Smith?
Yes, I have. Smith has lived in Burnsley County for the entire time I've worked here.
Are you aware of what he does for a living?
As far as I'm aware, he worked as a contractor before starting to rent out properties about 15 years ago.
Have you encountered any of his tenants in the course of your work?
Yes, notably the defendant who was his neighbor.
How was their relationship as neighbors?
I would say they had a very stressed relationship. I've received over half a dozen calls from both Eric and Kobe, from parking complaints to noise complaints.
Did you ever do anything to curtail future calls?
Yes, at one point I gave Eric Smith a security camera after he accused the defendant of breaking into his property.
Do you know what Mr. Smith did with that camera?
I showed him how to set it up and how to share the footage with the police department if he chose, but I'm not sure what he did after this.
I'd like to bring your attention now to the morning of April 30th, 2021. What were you doing at that time?
I was on patrol that morning when a call came around 9 a.m. to 46601 Raptor Road due to an old man's body being found. I recognized this as Eric Smith's address and responded.
What did you find at Eric's address?
I found Eric laying face down in front of his house. I checked his pulse and I unfortunately found none. So I began to inspect his body.
Was there anything significant on the body?
Yes, there are puncture marks on his left wrist that were those to be consistent of a snake bite, I believe.
How did you proceed after you investigated the body?
Well, I talked to Angel Russell, who was the one to find the body. They showed me to a dead snake. I believe it to be a rattlesnake because of its markings and fangs, but it was strange. It did not have a rattle.
How did you proceed after you found the snake?
Well, Angel told me that the snake had bitten Eric Smith from the mailbox, so I began to check out the mailbox.
I'd like to now direct your attention to Exhibit B. Could you describe this image to me?
Yes, this is a picture of Smith's mailbox that I took at the time. I'd say it sits a couple feet off the ground on some wood.
How did you find the mailbox that morning?
I found it open with a slot on the top measuring 1 3/4 inches across. There weren't any visible fingerprints, so I dusted for latent ones.
Did you find any?
Yes. Later on in the investigation, they were found to belong to Danny Emlings, Eric Smith, and the defendant. All of them, except for the defendant, could be ruled as Eric Smith's murder.
Was this image a faithful and accurate representation of the mailbox?
Yes.
Your Honor, at this time, I request that Exhibit B be moved into evidence.
Exhibit B is admitted.
Did you ever search the victim's home on that morning?
Yes. I found envelopes containing rent from Eric's tenants in his home, but I could not find the defendant's.
Did you ever talk to the defendant on that morning?
Yes, they had told me they hadn't heard anything that morning, but intended to drop off rent to Mr. Smith's mailbox the morning before. I decided to return to the station with the evidence I had collected.
Did you ever return to the scene at a later date?
Yes, I returned on May 1st, intending to interview Terry Edwards and Francis Yazzie, who are both Eric's neighbors.
What did you learn from them?
Well, Terry informed me of an argument at the defendant's mother's funeral where Eric and the defendant fought, and Yazzie was able to corroborate.
How did this affect your investigation?
I remember the camera and I retrieved an image from the morning of Smith's death, which showed snake tongs and a small object in the defendant's back garden.
I'd like to direct your attention to Exhibit A. Is this the image you just described?
Yes, this is the image that I just mentioned, which shows a part of the defendant's back garden and some objects.
Could you describe the contents of this image?
Yes, this image contains a pair of snake tongs, which are useful in handling any potentially dangerous snakes, and a small object. I'm not sure, but it could have been a rattlesnake's rattle.
Objection, Your Honor. This is speculation.
Your Honor, may I be heard? May I be heard?
Yes.
This witness is not speculating. They are stating their opinion, which they are entitled to do, as this is from common experience from living and working in the desert for over 2 decades.
I'm going to overrule the objection.
How did you proceed after you found this image?
Well, with what I learned from Edwards and Yazzie and the knowledge that the defendant had snake handling equipment at the disposal, I decided to talk to the defendant the next day.
What did you find when you did that?
They allowed me to search their property.
Was there anything significant in their property?
Yes, I saw a few books on venomous animals, a tub with around 5 rattlesnake rattles, and some snake-proof boots in the garage.
So with all the evidence you had collected and what you'd seen in the defendant's home, how did you conclude your investigation into Eric Smith's death?
Well, knowing all the history between the defendant and Smith, as well as the evidence I had collected, I concluded that the defendant most likely murdered Eric Smith and arrested them on June 3rd, 2021.
Thank you. No further questions, Your Honor.
Cross-examination.
Yes, Your Honor. May I begin?
You may.
For the convenience of the court, my name is Molly Tatum. You knew Mr. Smith for the last 20 years, correct?
Yes.
And you knew Smith served on the town council?
I did.
And Smith was known for being rude to his fellow council members, yes?
He was.
And you've known Miss Kobe for the last 10 years, yes?
Yes.
And you often get calls from Kobe or Smith complaining about each other, don't you?
Yes, I got calls from both of them.
And Smith admitted to trying to anger Kobe with these outbursts, didn't he?
Yes.
And Smith also admitted to damaging Kobe's prized succulents.
Yes, Your Honor. Hearsay.
Counsel.
This isn't hearsay. This is records collected by a public employee. Garrett would have reasonable knowledge of the calls between Kobe and Smith and their results.
I'm going to sustain the objection.
Motion to strike the testimony and the testimony of the question before.
That motion is granted. The answer will be stricken.
You said that you felt you were wasting your time with these calls, correct?
Yes, they were very childish.
Yes. You in fact said that Kobe and Smith were acting like children in your opinion?
Yes.
Thank you. Last October, you responded to a call from Smith who thought that Kobe had broken into their home, correct?
Yes.
There was absolutely no evidence that this occurred, though, was there?
No.
But despite that, you supplied Smith with a state-of-the-art security camera?
I did.
You responded to a call on the morning of April 30th, correct?
Yes.
And he found a body at 46601?
Unfortunately.
And Smith was pronounced dead?
Yes.
Angel Russell, the line worker that had been working that day, said they saw someone with a gardening bag and a metal trap at Smith's mailbox earlier that day, yes?
Yes, they told me that.
But Russell said they could not identify what was in the trap exactly, yes?
Objection, Your Honor. Hearsay again.
Overruled.
And
could you repeat the question? I did not get to finish.
Yes, I said they could not identify what was in the trap that day.
Yes, they were turned around and working, so probably not.
Yes. And on May 2nd, you remembered that you'd given Smith a camera, yes?
Yes.
And you checked the footage?
Yes.
And what did you find?
I found an image from Jamie Kobe's backyard with snake handling equipment and a small object.
Yes, and living in the desert, people use snake handling equipment to safely be around snakes, yes?
Yes.
And you found snake tongs in Kobe's home, yes?
Yes, I did.
And you even have a pair of these tongs in your department, yes?
Yes, we do.
When you were questioning Kobe later, you saw a jar with 5 rattlesnake rattles and a bottle labeled anti-venom, yes?
Objection, compound question.
I'm sorry, I didn't get the objection.
Compound question. This question calls for answers on 2 different objects that the officer saw.
Yes.
May I rephrase the question,
You
Your
may
Honor?
rephrase the question.
You found 5 rattlesnake rattles in Kobe's house, yes?
I did.
And a bottle of antivenom?
I did.
Is it normal to have, is it normal for gardeners to have these?
Objection, Your Honor, speculation and improper opinion.
Sustain. Rephrase.
No response, Your Honor. Kobe said that she found these rattles from time to time while in the desert, yes?
That's what they told me.
And based on the evidence you collected, you got a warrant and arrested Kobe on June 3rd, 2021, yes?
I did.
Thank you. No further questions.
Redirect.
None, Your Honor. May this witness please be excused.
Yes, the witness may be excused.
Thank you.
The prosecution's next witness.
Yes, Your Honor, the prosecution calls Dr. Charlie Dunn to the stand. The prosecution at the time requests a time check on direct examinations.
Prosecution has 3 minutes and 41 seconds left for direct and redirect examination, and the defense has 3 minutes and 25 seconds left for cross-examination.
Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
For the convenience of the court, my name is Madison Alwal.
For the convenience of the court, my name is Evie McNulty.
You may
I proceed? Thank you. Good evening, Dr. Dunn. Please state your name and qualifications.
My name is Dr. Charlie Dunn. I have a bachelor's degree in biology. I graduated medical school as well as completing a residency in clinical toxicology and a fellowship in forensic toxicology. And currently I am the chief medical examiner in Burnsley County.
Are you familiar with the snake that bit Eric Smith?
I am. I did a brief visual examination of it.
I would like to direct your attention to Exhibit D, which has the image that has been marked as Exhibit D for identification. Do you recognize this photo?
Yes, I do.
And could you describe what's in it?
It is an image of the snake that bit and killed Eric Smith.
And is this an accurate representation of that snake?
Yes, it is.
Your Honor, at this time, I request that Exhibit D be moved into evidence.
Exhibit E is admitted.
What did you find peculiar when you looked at the snake in this photo?
The most peculiar thing would probably be that the snake was missing a rattle. And I also noted that the snake was widest, its widest point was 2 inches.
And what do you already know about the behavior of snakes?
I know that snakes prefer to crawl into easily accessible spaces, especially if they are cool.
Now, describe your findings from the autopsy you conducted on Eric Smith.
I found 2 puncture wounds on Eric Smith's left wrist, which are consistent with a snake bite. I found acute tubular necrosis and epicardial hemorrhaging, which are 2 conditions that are also consistent with a venomous snake bite.
Are you familiar with the statement of herpetologist Tyler Clay?
Yes, I am.
2 minutes.
Is it your opinion as a medical professional that there are any correlations between Eric Smith's death and their previous health conditions, as Dr. Clay says in their statement?
No. I think that Eric Smith would have died regardless of his previous health conditions. I think that Eric Smith died due to a snake bite.
No further questions, Your Honor.
Cross-examination.
Yes, Your Honor, I may proceed.
You may.
For the convenience of the court, my name is Zora Martin Etamati. You have a degree in biology from the University of Central California,
Yes.
but you only have an interest in poisons and toxins.
Yes, I have an interest.
And you became chief medical examiner in 2015.
Yes,
However, you've only seen 1 death due to a snake bite in this area.
that's true.
And according to your statistics, death due to poisonous snake bite is extremely rare, correct?
Yes.
And this is because most snake bite victims seek immediate medical attention.
Yes.
But Smith did not seek immediate medical attention.
Smith did not seek immediate medical attention.
And are you aware that the snake was found in Mr. Smith's mailbox?
Yes, I am.
But snakes are known to squeeze into tight spaces such as mailboxes to escape desert heat, correct?
They are, although this is rare.
And it's common knowledge that Burnsley is in the desert.
Yes.
You examined the snake, correct?
Yes, I did.
But you only did a
visual examination.
But you only did a quick visual inspection of the snake.
Yes, just a quick visual examination.
And based on this inspection, you noted that the snake was missing its rattle.
Yes, I did.
And you identified it as a Mojave rattlesnake.
I did.
But Mojave rattlesnakes can lose their rattles naturally in the wild.
Yes, they can, although it takes a lot of force.
And Angel Russell, the line worker who found the body, their attempt to suck the blood out of Smith's wrist
2
is
minutes.
ill-advised.
It was ill-advised, yes, but
And
they couldn't have known otherwise. So,
and according to you, Smith's movement after the bite is also ill-advised.
yes, again, they couldn't have known otherwise.
And even more so, Smith's pre-existing conditions were worsened by the effects of the bite.
I wouldn't say that. I think that acute tubular necrosis can be a pre-existing health condition. However, in most cases, it's caused by the snake bite.
But you came to the conclusion that with proper medical treatment, that this bite would not have been lethal.
Yes, with immediate antivenom, the snake bite would not have been lethal.
Thank you. No further questions.
Redirect.
No redirect, Your Honor. May this witness be excused?
The witness may be excused. And the prosecution's next witness.
Your Honor, at this time, the prosecution has no further witnesses. Before we rest, I would like to ensure that Exhibit A has been entered into evidence.
Exhibit A is admitted.
At this time, the prosecution rests.
Thank you, counsel. We'll then turn to the defense case and the defendant's first witness.
Yes, Your Honor. The defense calls Francis Yazzie to the stand.
Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
Yes.
And this witness's testimony can be found on pages 47 and 48. And for the convenience of the court, my name is Stephanie Garcia Mora.
For the convenience of the court, my name is Shalin Joshi.
Could you please state your name and occupation?
My name is Francis Yazzie, and I currently make a living off of selling my desert landscape watercolor paintings, handmade jewelry, and belt buckles. I used to own the Blue Agave restaurant, but it was closed during the pandemic.
Where do you live?
I live at 401 Raptor Road, about half a mile or so down the road from Jamie Kobe and Eric Smith.
Could you describe your relationship with Miss Kobe?
Jamie and I have been good friends since Jamie moved into the neighborhood 10 years ago. We began to hang out early in the pandemic. We'd gotten very close because they would help me in building a drought-tolerant garden. We even considered going into business together after the pandemic.
And what was Miss Kobe's daily routine like?
Kobe gardened in the early mornings, took care of their mother for most of the day, and then gardened a little more.
In your testimony, you mentioned Miss Kobe seemed like a good business partner. May I ask why?
Well, Jamie is always a very patient teacher when helping me with my garden. Jamie is also very caring, which I noticed as they were a very devoted and loving caregiver to their sick mother.
Jamie sounds not only kind, but the epitome of a great business partner. Now,
Objection, Your Honor. The counsel's statement is argumentative.
Sustained.
Now, I'd like to discuss more about Mr. Smith. Did you know who Mr. Smith was?
Yes, Eric was Jamie's landlord and was disliked by many in town due to him selling marijuana to minors and being generally unkind. I did not like them too much either because they would harass Jamie and turn off their utilities.
Objection, Your Honor. Improper opinion.
Counsel's response.
May I ask, where was the improper opinion?
Well, I'm going to sustain the objection. Next question.
Have you ever witnessed Mr. Smith turning off Kobe's power?
Yes, on 2 occasions the power was off while I was at Jamie's house, which Jamie then claimed was because Eric wanted to get them to move in order to start a big cannabis grow operation.
Now, I'm curious, have you seen Miss Kobe recently?
Yes, Jamie came by my house on the day of their mother's funeral.
And how did Miss Kobe act while at your residence?
Well, Jamie initially looked upset, with good reason, since they had just got back from their mother's funeral. However, after about an hour, Jamie seemed to calm down to their even-tempered self, which was expected, considering they're such a patient and level-headed person.
Thank you, Your Honor. No further questions.
Any redirect?
Yes, Your Honor. Do you live on Raptor Road,
Yes,
close to the defendant?
that is correct.
And you and Jamie are good friends, is that right?
Yes,
And you knew Eric Smith.
yes,
And you've visited Jamie's house repeatedly, is that right?
that is correct. Yes,
Furthermore, Eric had a habit or a custom of shutting off the defendant's power, didn't they?
yes, I even witnessed it.
And you saw this happen twice, correct?
Correct.
You asked the defendant about it, is that right?
That is true.
And the defendant told you that Eric turned off the power to get them to move?
Yes,
You're also familiar with Eric's reputation in town.
yes,
And Eric wasn't well liked in town, was he?
he was not.
After witnessing Eric turn off the defendant's power, you told Eric to stop.
Yes, I did.
But Eric would always refuse
Yes, you would.
because he wanted his property back
Correct.
to grow cannabis.
Yes,
Now, on the 29th, Jamie spent time at your house after their mother's funeral, correct?
that is correct.
And when you were there, they seemed agitated.
At first, yes, but then they were calm after about an hour.
And an hour or so later, you would describe Jamie as being back to their even-tempered self.
That is correct. Yes,
No further questions, Your Honor.
Very well. Witness can be excused then. And the defense's next witness?
The defense likes to call Dr. Tyler Clay to the stand.
Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
Yes.
For the convenience of the court, my name is Zora Martinet Tamati.
For the convenience of the court, my name is Connell Barber.
Please state, thank you. Please state your name and occupation.
My name is Dr. Tyler Clay, and I am the director of the Southland Zoological Museum in California.
And what qualifies you to be here today?
I have a PhD in biology from the University of Central California with a specialization in herpetology, the study of snakes.
And what are some of your accomplishments in your field of herpetology?
Well, I actually recently published a book titled The Snake Whisperer: Life Among the Snakes.
And how did you get into herpetology?
Well, growing up in Southern California, I frequently encountered rattlesnakes, and I just remember being so fascinated by them whenever I saw them.
And what materials did you examine for the case today?
I've examined the photo of Eric Smith's mailbox as well as the rattlesnake that bit him.
And bringing your attention to the day itself, where was the rattlesnake found?
The rattlesnake was found in Eric Smith's mailbox.
Would you be able to recognize Smith's mailbox if you saw it today?
Yes, I would.
Permission to show an exhibit?
You may.
I'm now showing an exhibit previously marked Exhibit B. Can you identify this exhibit?
Yes, this is Mr. Smith's mailbox.
And can you confirm this is a clear and accurate representation of the mailbox?
I can.
Let the record reflect that the witness has properly identified Exhibit B. And I believe the prosecution has already moved Exhibit B into evidence.
Yes.
So why would the snake be in the mailbox?
Well, because of the hot desert climate that Mr. Smith and Miss Kobe live in, it is very likely for a snake to seek shelter from the hot desert sun in a shady place such as a mailbox. This is not the first case I have seen in which someone has gotten bit while retrieving their mail.
But how could the snake even get into the mailbox in the first place?
After analyzing the dimensions of both the mailbox and the rattlesnake, I came to the conclusion that it would have been entirely possible for the snake to come in through the front door of the mailbox were it left open, or more likely the snake could have squeezed in through the top slot of the mailbox.
And was there anything that stood out about the snake itself?
The snake had no rattle on its tail.
And would you be able to recognize the snake if you saw it today?
I would.
Permission to show an exhibit?
You may.
I'm now showing you exhibit previously marked Exhibit D. Can you identify this exhibit?
Yes, this is the Mojave rattlesnake that bit Eric Smith.
And can you confirm that this is a clear and accurate representation of the snake?
I can.
Let the record reflect that the witness has properly identified Exhibit D. And again, the prosecution has already moved Exhibit D into evidence.
Yes.
So why would the snake not have a rattle?
Well, the rattlesnake could have lost its rattle while shedding its skin and rubbing up against its surroundings. This is a completely natural occurrence found across many species of rattlesnake.
So Dr. Clay, did your evidence lead you to believe that the rattlesnake was planted in Mr. Smith's mailbox?
No, it is entirely possible, based on evidence concurrent with rattlesnakes in the natural world, that the snake could have entered the mailbox on its own accord.
Thank you. No further questions.
Cross-examination?
Yes, Your Honor. May I proceed?
You may.
Good evening, Dr. Clay. Let's be clear. You're not a medical doctor, right?
I am not.
You hold a degree in biology, correct?
Yes.
You've never been to medical school?
I have not.
You've never practiced medicine professionally?
No,
And you didn't conduct the autopsy in today's case.
I did not.
Yet you offer an opinion on the cause of death in this case, correct?
Yes, I did.
Which differs from that of Dr. Charlie Dunn, a medical expert and the one who conducted the autopsy today. Yes?
Yes.
You are, however, an expert in snakes, right?
I am.
And you identify the snake in today's case as a Mojave rattlesnake.
It is a Mojave rattlesnake.
Are you aware of the dimensions of the snake?
I am. I analyzed the snake firsthand.
It was 2 inches across, right?
It was.
Now, the Mojave rattlesnake is one of the most venomous snakes in North America, correct?
It is extremely venomous.
And it has a venom that may not show symptoms until someone has already gone past the point of no return.
Unfortunately, yes, this can be the case.
And this means that it is a potentially dangerous snake, right?
It is dangerous.
That you would recommend handling with special care and caution.
Absolutely.
And you would recommend using certain tools to ensure your safety,
Of course.
including a snake cage of some form, right?
Well, yes, a cage would be helpful.
And some snake tongs, right?
Yes.
However, despite these factors of its venom and your opinions on its potential danger, you believe it's still rare for someone to die from a rattlesnake bite, right?
Yes, this is due to the antivenom being widely available and people generally seeking out help as soon as possible.
However, in this case, the victim didn't take antivenom, right?
No.
Which, in your opinion, is disregarding medical advice?
Definitely.
Thank you. No further questions, Your Honor.
Redirect.
No redirect, Your Honor. May this witness be excused.
Witness may be excused. The defense next witness.
Yes, Your Honor. The defense calls Danny Emling to the stand.
Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
Yeah, I do.
And for the convenience of the court, this witness's testimony can be found on pages 52 and 53. And also for the convenience of the court, my name is Stephanie Garcia Mora.
For the convenience of the court, my name is Eva McCarthy. Can you hear me all right now?
Yes, we can.
Could you please state your name and occupation for the court today?
Well, my name is Jenny Emling, and I currently run a convenience store in town that has thankfully stayed in business during the pandemic.
And where do you live?
I live on Raptor Road across from both Jamie and Eric, and I am also a tenant of Eric's.
As a tenant, how would you describe the relationship Mr. Smith had with his other tenants?
Well, on several occasions in the past, I have noticed Eric having arguments with his tenants. He was the landlord and shut off utilities at the slightest provocation.
And how did you meet Miss Kobe?
Jamie and I met prior to the pandemic when I hired them to make my garden drought tolerant, and they did an amazing job.
From what you've seen, have you ever witnessed Mr. Smith and Miss Kobe arguing?
Well, from what I've noticed, Eric and Jamie argue with one another on multiple occasions. As I said, Eric shut off utilities, which upset Jamie. Eric would also blast loud music, which would upset Jamie, as it would anyone else who would have to endure such behavior.
Now, I'd like to talk more about Miss Kobe. Would you say they gardened regularly?
Yes, certainly. Jamie loved gardening and especially loved and cared for the animals in their garden. They avoided even hurting mosquitoes or other pests.
And did Miss Kobe have anyone else they care for?
They cared for their mother, that is, of course, until their mother passed away.
Did you go to Miss Kobe's mother's funeral?
Yes, I did.
And did you witness anything at all between Mr. Smith and Miss Kobe?
Yes, while at the funeral, I did notice that they had a bit of a heated argument.
Now, I'd like to fast forward a bit to the day that you found out about Mr. Smith's death. How did you find out?
Well, I was out of town to visit family in another county, and I got a phone call from the deputy telling me that, sadly, Eric had passed away. When I returned, a couple customers in my store told me that Jamie had been arrested for Eric's murder.
And how did you feel about this news?
Well, I was so shocked, especially since I've gotten to know Jamie as such a harmless and caring person.
Objection, Your Honor. Relevance.
Overruled.
Thank you, Your Honor. No further question.
Cross-examination.
Yes, Your Honor. You know the defendant, correct?
Yes, I do.
You're friends with the defendant?
Yes, Jamie is my neighbor.
You also knew Mr. Smith?
Yes.
You rented from Mr. Smith?
Pardon?
You rented from Mr. Smith?
Yes, I did.
And you paid that rent?
I did as well as I could.
Yeah, you were late to some payments.
Yes, I was.
You didn't get along well with Mr. Smith, correct?
Well, no, he was a difficult person and he would take a long time to do utility fixes but I guess some people are just like that.
So you did not get along with Mr. Smith?
No, I did not.
He would shut off your power?
Yes, he would.
He would shut off your water?
Yes.
You're not fond of Eric, are you?
I cannot say that I am.
So you're not fond of Eric?
No, I'm not.
You thought Eric was a terrible person?
I did not like him. I wouldn't say I thought he was a terrible person.
You would not say that Eric was a terrible person?
No.
You gave a statement in this case, correct?
I did, yeah.
I would like to direct your attention to page 52, line 13. I will read this aloud, and I would like you to follow along silently. I do not like to speak ill of the dead, but Eric was a terrible person. You said this, correct?
Yes, I did.
And this directly contradicts what you just stated?
I guess.
This directly contradicts what you just stated?
Yes.
I want to talk about the fight at the funeral now. In the weeks before Jamie's mother's death, you witnessed Jamie and Eric arguing, correct?
I did.
And after the death of Jamie's mother, did you attend her funeral?
Yeah. Mm-hmm.
You witnessed Mr. Smith come in, correct?
Yes, uninvited.
Yeah, he was not invited. This made the defendant mad.
Yeah.
Did you witness a fight between Jamie and Eric while you were there?
I did, yes.
And do you believe that Eric Smith killed Jamie's mother?
Yes, I do believe that.
Thank you, Your Honor. No further questions.
Redirect.
No redirect, Your Honor. May the witness please be excused.
Yes, the witness may be excused. And the defense's next witness.
Yes, the defense wished to call Jamie Kobe to the stand.
Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
Yes. For the convenience of the court, my name is Molly Tatum.
For the convenience of the court, my name is Maisie Higgins.
Can you please state your name and occupation?
Yes, my name is Jamie Kobe, and I used to work at the Blue Agave before it closed down due to the pandemic.
Where do you live?
I live at 46603 Raptor Road, where I lived with my mom for 10 years and was a tenant of Eric Smith's.
And what are you doing these days?
Due to my mom's health conditions, it made it very hard for me to get a job. She died late April.
I'm so sorry for the loss of your mother, Miss Kobe. How are you coping with the grief?
To be honest with you, I'm not doing very well, but I have been finding peace in my gardening and xeriscaping. It makes me feel as though I'm contributing positively to my environment and community.
I'm glad to hear that. I know it can be difficult to talk about, but if you do feel comfortable, can you discuss what happened the day your mother died?
Yes, it was April 22nd, 2022. I'll never forget the day. I was out gardening when Eric shut off my power, and I was too late. My mom died due to cardiac arrest on the way to the hospital.
I'm so sorry. I couldn't help but notice you said Smith turned off your power. Is that a common occurrence?
Yes, Eric would often shut off my power and electricity, especially during spring and summer, which are the hottest months of the year.
Let's discuss your relationship with Mr. Smith more. What's your past with him like?
Besides shutting off my power, he would grow and smoke cannabis, as well as blast loud music, come onto my property without my permission, and even put a camera up facing my yard.
Camera? What led to Eric putting a camera in your yard?
Well, we got into a bit of a fight, and I found some coyote scat, and I put it on his doorstep, but I am extremely embarrassed that I had this response. I know I was wrong.
Of course. And with everything that happened, it seemed that you and Mr. Smith had a really complicated relationship. Can you expand on how you feel about him?
Yeah, to be honest, I don't like Eric very much, but I would never hurt him, let alone any other living creature.
I imagine you come across your fair share of living creatures, though, living in the desert. How do you handle those?
Yes, I usually trap them to set them free in the desert later.
And how do you trap them?
I trap them using my humane animal trap.
Would you recognize it if I showed you it today?
Yes.
Permission to show an exhibit?
You may.
I'm now showing you Exhibit E. Mark, can you identify it for the court?
Yes, that is my animal trap.
Is it a fair and accurate representation of your humane animal trap?
Yes.
Let the record reflect that the witness has properly identified Exhibit E, and the prosecution, I believe, has already moved it into evidence.
Yes.
What do you use this trap for?
I use it to trap animals to set them free in the desert later.
And what kind of animals do you usually come across?
I come across rabbits, snails, snakes.
And do you know anything about snakes?
I do know a bit about snakes. In order to keep myself safe and the animal whilst gardening, it's always my top priority to treat the animal with respect.
And how do you handle the snakes that you do come across?
I handle them using snake tongues, snake-proof boots, as well as animal handling gloves.
Earlier, you said that it was hard to make ends meet without a job during the pandemic. How then did you pay for your mother's funeral?
Unfortunately, I had to sell some of my gardening tools.
And did Mr. Smith come to the funeral?
Yes, even though I didn't invite him, he came to the funeral.
Did you interact with him at all?
Yes, we got into a bit of an argument.
Can you elaborate on this interaction?
Yes, he asked me when I was going to move out, which made me angry, and I told him
Objection, Your Honor, hearsay, with respect to Eric Smith's statement.
Overruled.
What happened after the argument?
After the argument, my neighbor Terry Edwards separated us, and I went over to my friend Francis Yazzi's house.
The Yazzi's house often?
Yes, Yazzie is a great friend of mine. I'm very, very lucky to have them in my life.
Where'd you go after going to Yazzi's?
After going to Yazzi's, I wanted some time by myself, so I went and gardened.
And what'd you do the next morning?
The next morning, I collected what I could, money-wise, and dropped my rent off at Eric's mailbox.
After dropping off your rent, what did you do?
I had brought my gardening tool bag as well as my trap, which I do with me in the mornings, and I went on my way.
Thank you. No further questions.
Cross-examination.
Yes, Your Honor. Before I proceed, the prosecution would like to request a time check on cross-examination.
Prosecution has 3 minutes and 44 seconds left for cross-examination.
Thank you. May I proceed?
You may.
Good evening, Ms. Kobe. I'd like to begin tonight with your background. You've lived in Burnsley County for around a decade now, right?
Yes.
And you used to work at the Blue Agave restaurant in town.
Yes, that is correct.
Now you work as a freelance Xeriscaper, though, right?
Yes.
That hasn't turned out for you well financially, though.
Not a lot, people during the pandemic don't have a lot
Objection,
of
Your
money
Honor.
to pay
Witnesses
me.
being non-responsive.
Sustained.
Yes or no, that hasn't turned out well for you financially, right?
Yes.
This has left you to survive off of your state unemployment and your mother's state disability check,
Yes.
which has meant you aren't able to pay rent in full consistently.
Yes.
That has increased tensions with your longtime neighbor and landlord, Eric Smith.
Yes.
Now, you had a tenuous relationship with Mr. Smith, right?
Yes.
He would enter your property,
Yep.
destroy your, quote, prized succulents,
Yes.
and smoked cannabis,
Yes.
going so far as to ignore medical advice and his prescriptions and smoke cannabis instead.
Yes.
Now, he attempted to illegally evict you sometime last year, right?
Yes.
But after failing to do so, he started to cut your power,
Yes.
which was the only thing keeping your mother's life support running.
Yes, but she was also very old.
Is that a yes?
Yes.
Now, ultimately, your mom would pass away during one of these power outages, correct?
Yes, but she was very old. It was going to happen at some point.
Is that a yes?
Yes.
In fact, she passed away about a week before Eric did, right?
Yes.
In fact,
Objection,
Eric,
Your Honor, relevance.
Overruled.
in fact, it happened, Eric died just 2 days after your mother's funeral,
Yes.
2 minutes.
where Eric had arrived uninvited,
Yes.
and you two entered into a verbal argument.
Yes.
At which point, you directly blamed Eric Smith for your mother's death. Yes or no?
Yes.
Thank you. Now, you later returned home in the evening, correct?
Yes.
As a gardener in the desert, you have to be aware of potentially venomous animals, right?
Yes.
Including the Mojave rattlesnake,
Yes.
a snake that you know to be prevalent in Burnsley County,
Yes.
a snake that you know requires special care when handled,
Yes. Most poisonous snakes do.
and a snake that you know to be potentially deadly, right?
Yes.
Now, the very next day, you approach the victim's mailbox, right?
Yes, to drop off my rent.
1 minute.
You are aware that rent was not found in the victim's home, though, right?
Yes.
You brought some of your equipment with you, right?
Yes, I normally do in the mornings.
And to be clear, you carried a cage
Yes.
and a canvas bag for carrying tools, right?
Yes.
Though you don't have all of that equipment in your possession today, right?
No, I had to sell it.
So just to be crystal clear, you
3
sold
seconds.
a hunting knife,
Yes.
your humane animal cage, as you call it,
Yes.
and your snake tongs.
Yes.
Thank you, Your Honor. No further questions.
Redirect.
Yes, Your Honor. May I begin?
You may.
Miss Kobe, how do you treat the animals you come across when you garden?
I try to treat them as humanely. and
Objection, Your Honor, beyond the
respectfully.
scope of cross-examination.
Overruled.
Your Honor, may I be heard?
No, I'm going to overrule that objection.
Did you get to finish your answer?
No, I didn't. I try to treat them as humanely and respectfully as possible. That's why I'm part of some animal rights organizations.
And why did you have your humane animal trap when you were dropping off your rent?
I had it with me because I carry
1
my
minute.
stuff around with me in the mornings while I garden.
Thank you. No further questions.
Very well, the witness may be excused. Any additional defense evidence?
None, Your Honor.
The defense rests.
Yes, Your Honor.
Very well. We've reached the stage for closing arguments, the prosecution having rested, the defense having rested. Prosecution will give its closing argument first. Prosecution ready with its closing argument.
Yes, Your Honor. May I proceed?
You may.
The defendant is angry. Eric Smith has done nothing but harass and humiliate them for years on end. But this time, he has truly gone too far. This time, the defendant believes that Eric Smith killed their mother. And now, they want nothing short of revenge. So, they'll use the one thing they know best: nature. That is the story of the trial here tonight. However, as the defense will likely remind you in just a brief moment, a story is not good enough to convict the defendant. No, we, the prosecution, hold the burden of proof. We must prove beyond any reasonable doubt, not only that the defendant was responsible for the death of Eric Smith, but in pursuing that action, they acted willfully, deliberately, and with premeditation, and thus satisfied the three elements of first-degree murder. We will do this by asking and answering two simple questions about the trial tonight. Why and how? Let's start with why. Why would the defendant murder Eric Smith? Why was that snake in the mailbox? Well, it's relatively simple. As you heard from Deputy Sheriff Tony Garrett, the defendant and Eric Smith had a long and tenuous relationship from before the pandemic even began. They responded to half a dozen or more calls over the course of several years. It only got worse with the pandemic. As the defendant struggled to pay rent, Eric did what he had already done to Danny Emlin and started cutting their power. Francis Yazzie even saw it twice with their own eyes. Ultimately, this would prove to be the final straw, as during one of these power outages, the defendant's mother would die. About a week later, at her funeral, the defendant could be seen and heard arguing with the victim. And in that moment, screamed and directly blamed Eric Smith for their mother's death. That's why the defendant would murder Eric Smith. But how? How did the defendant murder Eric Smith? How did the snake get into the mailbox? Well, that is going to be the most crucial question in today's case. And the defense contends that with the testimony of Dr. Tyler Clay, they have provided a more than reasonable explanation for a snake climbing into the mailbox and just biting Mr. Smith completely of its own accord. However, there are just three simple problems with that theory. First, the mailbox was elevated multiple feet off the ground and would thus be more difficult to access, even for a snake. Second, that mailbox would not be an enticing target. As Dr. Charlie Dunn stated, snakes seek out shady, cool places. That mailbox was the same temperature on the inside as the outside air, 68 degrees Fahrenheit. And further, the 6-inch slot on top of the mailbox would have guaranteed the entire space was illuminated. That was no enticing target. Finally, even if the snake had gotten on top of that mailbox, it could not have fit in. Dr. Tyler Clay admitted that the snake was 2 inches across, whereas, according to Deputy Sheriff Tony Garrett, the mailbox slit was 1 3/4 inches. There is simply no reasonable way for a snake to have entered that mailbox of its own volition. And that's where the defendant comes in. You see, they knew that they could catch one of these snakes. It was prevalent in Burnsley County area, and they had the tools necessary to handle it. They knew the snake was dangerous. But most importantly, they knew that Eric Smith would likely ignore medical advice and thus would be more susceptible to a snake bite. So there's the plan. All the defendant needed to do was set it into action. So they left the funeral and went home to guard. They talked to Terry Edwards about something important. That was it, catching a snake. That was their important task for the day. So they did. And the next morning, they cut off its rattle and left it along with their snake tongs to be discovered on Exhibit A, footage from the victim's own camera. Then they left their house, carrying a snake, their tools, and revenge on their mind. Angel Russell watched them, the only person to approach the mailbox that morning, staring anxiously down at this snake, and then turned away, leaving them with practically infinite time alone to place that snake in the mailbox.
2 minutes.
Even in the moment that would prove to be his death, Eric Smith knew who had struck him. It was Jamie. All that was left for the defendant was to cover their tracks. So they sold their equipment the very next day, scattering the evidence to the wind. That is how the defendant murdered Eric Smith, with a snake and with what they know best, nature. But the answers to these two questions must align with someone acting willfully, deliberately, and with premeditation. So let's go through those individually. Someone acts deliberately if they weigh the consequences of their actions and choose their methods appropriately. As I stated, the defendant knew three things. They could catch a snake, the snake was deadly, Eric Smith wouldn't seek medical attention. They chose their methods appropriately. Someone acts willfully if they intend to kill, and with premeditation if they do so in advance of the act. Listen to the defendant's own statements.
1 minute.
As overheard by Terry Edwards. This is it. I'm finally going to do it. I am going to kill him. Make no mistake, Your Honor. The defendant wanted Eric Smith dead and decided that fact well before the act. There is no doubt left in this case. We have proven that the defendant was responsible for placing that snake in the mailbox, as they were the only person who could have. And in doing so, they acted willfully, deliberately, and with premeditation in the murder of Eric Smith. Find them guilty.
Thank you, counsel. The defense's closing argument.
Yes, Your Honor. May I begin?
You may.
Jamie Kobe, a kind, hardworking woman who is simply trying to take care of her mother and contribute to her community, is being wrongfully accused at the stand today. Your Honor, my client is being charged with first-degree murder and voluntary manslaughter. I will be breaking down both of these charges today to show you why there is insufficient evidence to charge Ms. Kobe with any crime. According to jury instructions, the court must be convinced that the only reasonable conclusion from circumstantial evidence is that the defendant was not guilty. And if there's more than one reasonable conclusion and one points to innocence, you must find Jamie Kobe not guilty. Your Honor, the defense has called 4 witnesses to the stand to prove the innocence of Jamie Kobe. You learned about Ms. Kobe's kind and good-hearted nature. After losing her job at the Blue Agave during the pandemic, she wasn't able to find a safe job because she was so committed to caring for her ill mother. Ms. Kobe is generous and loves spending time with her family and her loved ones. After her mother's tragic death, Ms. Kobe was completely distraught. During the funeral, Mr. Smith came uninvited, understandably upsetting Ms. Kobe. They got into a bit of an argument, and afterwards, Ms. Kobe went to de-stress with her close friend Frances Yazzie. Then she went back to her house and gardened that evening to take her mind off her grief. Next morning, Ms. Kobe awoke, paid what she could of her rent in Smith's mailbox, and went on her way. The prosecution tried to tell you that Ms. Kobe was scheming to kill Smith from the moment her mother died. But in reality, Ms. Kobe was numb and grief-stricken, with absolutely no emotional energy to exert, especially in the killing of another. They tried to exaggerate the small disputes that Mr. Smith and Ms. Kobe had over the years. It's no secret that they didn't like each other, but to go as far as to plant a rattleless rattlesnake in a disliked landlord's mailbox is a poorly spun story. Ms. Kobe and Mr. Smith didn't get along, but that is not a reason to kill someone. There is most certainly reasonable doubt that Jamie Kobe committed this crime. Now, let's discuss the charges. Throughout this trial, we argued that the defendant, Jamie Kobe, did not place the rattlesnake in the mailbox of Eric Smith. We've seen that Ms. Kobe did nothing to the mailbox except put what she could of her rent in it on the morning of April the 29th. And secondly, that the defendant had no intent to murder. Ms. Kobe is a down-to-earth and level-headed person. After cooling down after the funeral with her friend and then gardening, she would have been in a stable emotional state by the next morning, though still grieving terribly. In other words, she wouldn't have any intent of harming Smith. She would be focused on her own sadness. To prove that someone is guilty of first-degree murder, the prosecution must prove that it was willful, deliberate, and premeditated. Ms. Kobe had come home from her mother's funeral the night before, exhausted, drained, and upset. She was focused on her grief and her plans for the future regarding where she would live and how she could possibly go on without her mother, not intending to kill her elderly landlord. She had not the mental capacity or the ounce of cruelty it takes to even consider killing another human being. The prosecution has only circumstantial substantial evidence. One of their main points being that Russell witnessed Miss Kobe with a gardening bag and a metal trap at the mailbox that morning. However, we heard from Frances Yazzie that Miss Kobe often gardens in the morning. So this is the clear explanation for why she has her gardening tools with her in the morning. This provides a vast amount of doubt that Miss Kobe committed this crime. Miss Kobe was angry at Mr. Smith, and they had a difficult relationship. But she's been honest about her feelings towards him throughout the trial. She's proved herself to be a kind and hardworking person who would never dream of hurting an animal, let alone a neighbor. Eric angered people around town, and there are eyewitness accounts of his bad actions. So it's understandable that Miss Kobe and him didn't get along perfectly. Adding to Mr. Smith's ignorance, he didn't seek medical attention after getting the bite and didn't treat his pre-existing conditions that only exacerbated his cause of death.
2 minutes.
Furthermore, it's common for snakes naturally not to have rattles, and living in a rural area, it would have been seen as normal for snakes to crawl into mailboxes. The missing rent money is easily explained by the fact that Angel Russell saw letters falling from the mailbox as Smith was bit. After leaving her mother's funeral on April 28th, Miss Kobe responsibly went to cool down and garden, a known activity of hers. The next day, she dropped off her rent. Nothing more. It's heartbreaking that we're scrutinizing a woman who has already been through so much. Your Honor, my client did not put a rattlesnake in the mailbox of Eric Smith. She would never do such a thing. At the end of this trial, the defense asked you to find Miss Kobe not guilty on all counts. Thank you.
Thank you, counsel. Rebuttal from the prosecution.
Yes, Your Honor. Danny Emling lied to you on the stand tonight, attempting to conceal their hatred of the victim. If the defense's own witnesses cannot keep their story straight and try to hide their hatred for the victim, how can you trust their story of a childlike feud and an innocent gardener who wouldn't hurt a fly? The defense further claims that the good character of the defendant provides doubt in this case. However, their character is not in question. What is in question is the statements that they made in the lead up to Eric Smith's death.
30 seconds.
Listen again. This is it. I'm going to kill them. Your Honor, the defense has not provided a reasonable explanation or alternative theory to our own. Their claims lie on the back of lying witnesses, flawed testimony, and flimsy evidence. I will reiterate, the defendant acted willfully, deliberately, and with premeditation in the murder of Eric Smith. Find them guilty.
Thank you, counsel. And the defense final rebuttal.
Yes, Your Honor, may I begin?
You may.
My opposing counsel claims that Miss Kobe, leaving the funeral of her mother, had revenge on her mind. This was not the case. She went to her friend Frances Yazzie's house, had tea, and calmed down. Then she went to her home to garden. Nothing more. She was simply trying to take her mind off the grief. She wasn't plotting anything. She is a stable, kind person who would never dream of hurting a human, let alone any living creature. Furthermore, the prosecution has failed the burden of proof, as there are more than one possible explanations for Miss Kobe's action.
30 seconds.
There is reasonable doubt that Miss Kobe did this, and it would be a terrible thing to sentence a woman who's already been through so much and irrefutably did not commit this crime. Lastly, Miss Kobe didn't have the snake equipment because she had to sell it to pay for her mother's funeral because of the dire financial situation she's in. No malicious intent was there. At the end of this trial, the defense asks you to find Miss Kobe not guilty because she isn't. Thank you, Your Honor.
Thank you, counsel. The evidence having been presented and the arguments of counsel having been considered, the court finds that the evidence in this case is controlled by California Criminal Jury Instructions 521 and 570. It appears that the defense is of the position that Ms. Kobe did not do it, rather than relying on the alternative theory that this event might have occurred given a sudden quarrel or in the heat of passion, thereby negativing any deliberation or premeditation. Given all of the evidence and having considered people's burden of proof, I'm satisfied people have met their burden of proof that the rattlesnake was in fact planted in the mailbox. I therefore find the defendant Kobe guilty of the charge of first-degree murder. The bailiff will remand defendant Kobe for commitment to the California Department of Corrections. And so we are done. Congratulations to both teams. This was a really fantastic presentation. These are obviously two very well-coached teams. I want to observe as well that as to the defense team, Team C, I believe we were together last Thursday when you folks were all in mask. I have to say it was such a remarkable improvement to see all of your faces. The communication was so much better, and there was just tremendous improvement, not only in that regard, but also in the substance of your delivery, Team C. So congratulations on that. On both sides, as far as the pretrial attorneys were concerned, really remarkable control and familiarity with the facts of the cases, and your ability to stay on track when I tried to get you off track with my questioning, and knowing how to distinguish the cases. It was really great presentation by both of you. And with respect to the examining attorneys, just really a great job of doing crisp, concise presentations. The direct examiners let their witnesses tell the stories with questions that were in no manner leading at all. Very precise, crisp questioning on direct. The cross-examinations I thought were all excellent. The witnesses embodied their characters. I really enjoyed the contrast between the prosecution medical expert toxicologist with the defense snake behavior expert, the herpetologist, and the two of you did really nice jobs in portraying your role, as did all of the other witnesses portraying their characters. I'm gonna give Mr. McGregor or McDonald special commendation. You certainly embody the role of a prosecutor. You got all the countenance of a prosecutor, and you really did a nice job with carrying your case. And our deputy Garrett, I think portrayed by Miss McNeil, also did a nice job of presenting the prosecution story as a deputy sheriff would, and there was a great cross-examination done, Deputy Garrett as well by our defense team. So just really a spectacular job. You folks were indistinguishable from licensed practicing attorneys. So I can't tell you enough how impressed I am with the presentation on both sides. So congratulations. I think it'd be appropriate if we had our scoring attorneys, if they had any additional observations they'd like to make, any of our scoring attorneys can jump on in.
I'll start. Thank you, guys. This was a great job. I want to reiterate, I agree with everything Judge Burdick said. The pretrial motions were done really well. Great job understanding the law and applying the facts to the law. I do some appellate work where I have to make arguments using these very same cases. So you're doing lawyer work, and Judge Burdick's a tough audience. You might want to consider appealing that ruling. The opening statements were good, straightforward, convincing, good use of evidence. Judge Burdick was right about the cross and the redirect. He really elicited the facts well. The story kind of came alive. I read the material, but I don't know, it just unfolded as you elicited questions from your witnesses, both on direct and on cross. And the witnesses, you were in character. You looked like you put a lot of thought into your character, and that you had fun with it. And you could tell you were, having fun with it, and it just made it all the more interesting to watch. And it probably helps with the scores as well. What else here? Let me see. It was apparent that everyone knew their case, knew the file, and that's most important. You can only work with what you have, so you need to really know it well. And then when you have command of that file in the case, you work it, and you guys all did that. Closings are crucial, and you both put a lot of work into your closings. I commend all of you. Thank you so much, and good luck as you proceed.
Ralph Boroff here. I'm one of the scoring attorneys. Everything that Judge Burdick had to say, of course, I would agree with. And Gregor McDonald, if you don't become a lawyer, you'll make a great radio announcer. I thought everybody did a really excellent job, and it shows that you put a lot of work into it. I think one thing I want to say, and I've said it before, is that there are a couple of products here that you need to recognize. Some of you will go on to become lawyers, hopefully just a few of you, but the reality is that through this activity, you're learning something about analytical thinking. And analytical thinking is something that you use every day. You may not recognize it as you're doing it, but if you go to the grocery store and you're buying yogurt, do I buy this brand or that brand, or this flavor or that flavor? And these kinds of things where you use logic in your decision making, and then carry it further into the next step of what inferences can I draw based upon that information. These are very valuable skills that you will use all through life. The second point I want to make to you is that you now have a certain expertise on the workings of your justice system. And other students at your school who didn't participate in the moot court don't have that expertise. And you're to be commended for taking the time to develop some understanding of your justice system, and also encouraged to study it further. Every day there's opportunities for that. Every day you pick up the newspaper and there's some kind of story about what's going on in the justice system. Sometimes it's good, sometimes it's bad, but it's always there. So you did a great job. I'm pleased to hear you folks do it again tonight. Thank you.
Yeah, hi, my name's Paul Peterson. I'm a local attorney here in Santa Cruz. And I definitely want to echo everyone else's comments and really lead with the fact that the hard work that you've all put into this is so evident. Everyone's preparedness, everyone's ability to think on their feet, everyone's ability to, look into their, the actual materials and, reach for that fact or for that information that you need at that moment was very much on display. And one thing in particular that I enjoyed about this particular trial was how there was very much good themes from both sides that were complementary in a way, because it really, the prosecution wanted to hammer on the fact that the defendant was really angry. The defense wanted to hammer on the fact that the victim was a jerk. And it kind of played out in a really interesting way, that those sort of complementary themes. And it was really helped by some of the best direct examination by both sides that I've seen while judging this, because so often, it's scripted, but it didn't feel scripted. It felt like I was getting all the information that I needed. And, sometimes you don't know it as well. Sometimes the problem is that because you guys have lived with the case for so long, it so well that you actually aren't as good at communicating it. But that wasn't the case here to people who don't know it as well. But you guys really knew how to tell us what happened and the information that you were trying to get to us. And so I thought it was really good. And that was, of course, helped because I thought that the witnesses all had a really good sort of energy and personality. It's a different sort of acting than like stage acting, right? You don't get to be, super demonstrative, right? But you're able to portray through an energy, through little turns of phrases, a great sort of personality that livens up the presentation. And to be perfectly honest, makes you believable or not believable, when you're doing this. And so I thought everybody did a really great job with that. So once again, great job, everybody.
Ms. Simonson?
Yes, hi, I'm Heidi Simonson. I was very pleased to be a part of this particular trial. As you've heard, both the teams, you're excellent teams. I think the one thing that I would add is that both the witnesses and all of the attorneys were very good listeners. You listened well to the other side's arguments, you listened to your witness, you listened to the other side's witness, and you had appropriate questions or comments based on that. I think part of this exercise is not only speaking, but also listening and being able to think on your feet. And I was very impressed with both teams' ability to do so. And I look forward to adding more specific comments for each of you, which you will be able to receive through the county so that you can improve what little there is to improve and get some specific feedback. Thanks again.
Thank you all, and thank you all for our scoring attorneys. I want to especially commend our attorney coaches, Ms. Sayar, Ms. August. I know firsthand Ms. August is with me every morning in the courtroom, the deputy public defender here, and I try to set things in the afternoon, and she asked me not to because she says she has her obligations with her coaching commitments with you all, and it was evident she put in the time, you put in the time. Ms. Sayar obviously has a group of very coachable students and has done a great job as well. So congratulations to them for all the hard work, and thanks to them for all the hard work that they've put in, as well as our teacher coaches as well. Are there any comments or questions from the teacher coaches or our attorney coaches? Very well, we will let you folks move on with your evening. Dr. Hoy, any final closing comments?
Yes, sir. I sent you a comment in your chat, and then also I just want to remind the scoring attorneys to make sure that they have their score sheets in by 9 o'clock this evening. It was about irregularities.
Yes. Yes. So I apologize. I did not give you folks the 30 seconds that you should have had to note any trial irregularities. There were none that leaped out to me, so I probably skipped over that. I also want to apologize for the dysfunction of my equipment in the early stages of this. I'm sure that was distracting to you folks not being able to see me. So I'll have our tech folks, before you get on to the final rounds, make sure that all of our equipment in each of the chambers is working correctly. I apologize about that. Any other observations or comments? Very well. So congratulations again. Very nice job to all of you folks. We really appreciate your hard work. Good luck as you go forward. And we'll be interested in tracking how you folks do at your finals and going on forward into the regional competition. Thank you all very much, and good night.